Yesterday, on the 4th of July, we got a very weird and seemingly sudden ruling from a federal judge in the Western District of Louisiana with some broad First Amendment implications.
A federal judge barred parts of the administration from contacting social media platforms about online content. Now, the ruling came in response to a lawsuit brought by Republican-led states alleging that the White House went too far in its efforts to curb content that challenged vaccines or threatened elections.
So this federal injunction handed down by this judge, as of yesterday, bars key federal agencies, including the CDC, the Department of Justice, and the Department of State, from even contacting social media platforms like Twitter, Facebook, and Instagram over concerns like misinformation on COVID-19. In the ruling, the judge accuses the federal government of some pretty heady stuff, saying they were running an Orwellian ministry of truth, the suppression of opposition and dissent. When you do a little Googling, you quickly discovered the plaintiffs, the Republican attorneys general in Louisiana and Missouri, very clearly filed this case in this small district in Louisiana because they knew there was a good chance they would get this guy on your screen, Judge Terry Doughty. That's the same judge who blocked the vaccine mandate for healthcare workers in the middle of a once-in-a-century pandemic. Joyce Vance is a former U.S. attorney for the Northern District of Alabama, now a professor at the University of Alabama School of Law, and she joins me now. Joyce, I got to say, I have read most of this opinion, and it's a real kind of head scratcher. Just take us through what the judge is ordering here.
So the judge, in essence, is shutting down communication between broad parts of the federal government and the social media platforms. And Chris, this is a two-way exchange where the government shares information with the private sector about threats and risks, and the private sector shares its own information with the government. None of us are safer with this sort of exchange shut down.
Yeah, and I can understand and be sympathetic to, in the abstract, concerns about government coercion vis-a-vis speech platforms like Facebook or Twitter. It doesn't strike me as crazy, right, that you would have those concerns. In this specific case, there's a lot focused on COVID, and it was interesting to me this. Like, here's Fauci on TV on MSNBC. It's cited in the ruling talking about hydroxychloroquine. Take a listen.
All of those trials show consistently that hydroxychloroquine is not effective in the treatment of coronavirus disease.
Now, that's true. I mean, and has been true, and is actually importantly true, because lots of people were trying it and it wasn't working. It's important that you know that it's not effective. And then the ruling by this judge says Dr. Fauci made statements on Good Morning America and on Andrea Mitchell Reports that hydroxychloroquine is not effective in treating the coronavirus. Social media platforms censored the America's Frontline Doctors video on the benefits of hydroxychloroquine. But there's no causal relationship or even coercion alleged here. He just seems to be implying it in a federal judicial order.
You know, I sense your frustration, Chris, and I want to echo it here, because the allegation is a First Amendment violation by the government, that the government is compelling or restraining speech. And there's none of that established in this complaint. This is a preliminary injunction. The plaintiffs, the attorney generals, and other parties have to show a substantial likelihood of success on the merits. But they can't show that the government was telling these companies that they had to remove speech from their platform just because Dr. Fauci was on television speaking the truth.
There's also this question that kind of haunts this case when I saw the ruling, which is this sort of forum shopping problem. We saw it's most famously been a problem with Judge Kaczmarek, who is a district court judge in Amarillo, Texas, where the plaintiffs who wanted to get mifepristone taken off the shelves went, and they not only sued, but they tried to get a nationwide injunction. They succeeded in him issuing a nationwide injunction. It was later stayed by a circuit court that would, cut access off for people across the country. It just seems like a very clear playbook here to file this suit in this part of Louisiana, knowing you're getting a guy. And I wonder what you think of it as this sort of loophole jurisdiction hacking that we're seeing increasingly.
Yeah, so I think this situation is a little bit different. I mean, I think you're absolutely correct to point out that they sought this particular judge out because they were aware that he had granted a series of injunctions in COVID vaccine cases, and he seemed to have a lot of animosity towards vaccines and the government's approach to COVID in general. But this is a judge who was confirmed 98-0 in the Senate. He's someone who was well qualified. The ABA rated him that way. He had been both a prosecutor and a state court judge. He seems to have an issue in this one area. And what you would expect to happen is that the Fifth Circuit would reverse him very quickly. But the Fifth Circuit, of course, has become an uber conservative circuit. And whether or not they will do that remains to be seen. There are a lot of problems with this order, not the least of which is that the plaintiffs don't seem to have standing, that basic doctrinal hurdle that parties have to pass to be in court. There are so many flaws in this case. Whether the Fifth Circuit takes it on remains to be seen.
Yeah, we should note the Fifth Circuit is also the appellate court for Judge Kaczmarek, and there's lots of people who feel like the Fifth Circuit's inability to rein in, sort of avant-garde federal district judges and their orders has been part of what has essentially, allowed for these kind of nationwide injunctions to happen.
It has definitely contributed to that mood. Nationwide injunctions, have been a thing on both sides of the political aisle. But the way that they're being used here in connection with judge shopping is particularly pernicious.
Yeah, I'm going to be curious to see what the Fifth Circuit does with this, and I think it's headed right for the Supreme Court, actually. We'll see what they make of it. Joyce Vance, thank you very much.